Yes, Your Lordship. Lordship, I beg to make a mention of item number 7, Your Lordship. As the conducting counsel is on leave, Your Lordship, I pray this matter may be listed after 3 weeks, Your Lordship.
I think we have made it clear last time that no more adjournment in this matter.
Conducting counsel is on leave, Your Lordship.
You are there.
Last chance may be given, Your
Mr.
Lordship.
Kanta is here, he can start. You can reply in the next day. You take down notes. Reply.
Let it be a last chance, Your Lordship, because I can understand when the senior is not there. Just let it be, maybe
After
just
3 weeks, Your Lordship.
What?
3 weeks, Your Lordship. 3 weeks, Your Lordship.
Why 3 weeks? That will be too. Shortest possible date. She's there, she can argue.
You see, you, as our Chief Justice has said, you get, this is the opportunity you get to study the case, get advice from your senior colleague, do it. You are competent enough. You can do it on instruction, why not? Otherwise, if you just wait for senior, we understand. See, a person is a person. Sometimes he may fall sick, sometimes he may not be available. Sometimes he's in some of the courts. That is why we have a battery of lawyers to charge of this. See, now I don't have any case today. On prayer made by the respondent, seeking accommodation on the ground that the senior conducting counsel is indisposed. The same not be objected to by the petitioner. Matter is adjourned. List the same after 2 weeks.
Highly obliged, Your Lordship. Please, Your Lordship. I beg to mention item number 6, Your Lordship.
I don't have any matter in court today. Matter will be taken up. You are there. You are the counsel.
Yes, Your Lordship, but
We'll take it up.
From daily list, item number 1.
Yes, Mr. Sen, what is this about?
Please, Your Lordship. The matter is coming up for admission hearing today on the objections filed by the respondents as to the maintainability of the case, my Lord. This writ petition challenges the administrative action of the district council.
But one thing, if I'm not mistaken,
Lordship.
when we deal with issues of maintainability,
My Lord.
wouldn't it be convenient if the whole, the matter as a whole is taken up,
I was always of the view, my Lord.
and if the issue of maintainability is to be decided
Correct.
as a preliminary issue, that would be done so by the court.
We can look at the
Otherwise,
entire.
what happens is very often I've seen here, we go for hearing on admission, matter is heard on maintainability. Few months down the line, 1 year or 2 years down the line, issue of maintainability is decided, and the main issue is left pending again. It goes
That
on.
goes into cold storage. That's exactly what happens my Lord. In the archery matter. Lordships will recall.
Same thing.
They vigorously contended that the matter was not maintainable. Lordships heard it, and now the main matter has gone into cold storage. So, in fact, the only two parties who filed the affidavit restricting themselves to the question of maintainability is the district council and the respondent number 7. The respondent number 6, on the other hand, has adverted to all the pleadings. They filed it on merit.
I'm in agreement, Your Lordship, that perhaps the entire matter can be looked at the same time. so that time is not wasted. So in
Because
that
I'll
case,
point out, my lord, what's happened is that they're raising certain issues which are directly connected to the merit.
so let this be for in
And
that case
also,
for
may I just
hearing.
point out there was one of the objections which was raised with regard to non-joinder of necessary parties. Now, what's happened is that, my lord, these mintris had filed a complaint before the executive committee of the district council. Now, when the complaint was considered by the executive committee, inquiry was ordered. When the inquiry was proceeding, it was proceeding against two persons, that is the former CM as well as his deputy CM. Now, in my writ petition, I've not arrayed the deputy CM as a party. Now, that is one of the grounds that has been taken. Now, I've taken instructions from my client. It turns out that the deputy CM, Mr. Twelson Manik CM, expired as far back as December 22. This ought to have been known to by the respondents. So that again, that plea is not sustainable.
So as of now, there's no deputy CM.
No, the post of deputy CM fell vacant.
Yes.
Yeah,
So
Twelson Manik
there's no
CM
incumbent
expired.
now.
My lord.
Presently there is.
So his being joined as a party here does not arise.
Is it the person or the office?
The person, my lords. As soon as the order was passed for the inquiry, the office fell vacant. I'll show you lots from the records. But he expired only in December 22. And my writ petition was filed in August 23. So I could not have joined him in any case.
So let this matter come up for full hearing, Your Lordship.
We can do it now.
The district council has not filed their affidavit to the merit of the case, my lord.
Not, I'll just take instruction on that point. Maybe it may be posted for final hearing. There's no issue on that, Your Lordship.
We have filed in WPC 166. 263 we have filed only an objection. Challenging the maintainable lordship. That is the case, then I will be required to file the
So you file an additional counter affidavit or additional affidavit?
Lordship. There's no need to hear it. There are certain issues which are raised were directly connected to the main issue. And just for your lordship's record, we procured a copy of the death certificate of Mr. Twelson Manik CM.
So who has raised this issue of
The district council as well as the respondent number 7.
You have raised this issue of
Yes.
Yes, yes, this is not a matter which started just in 2023. It's a matter which originated much before that. The course of action
Yes.
started much before that. When the incumbent was still under suspension, that is Mr. Latho Manik Sim. The original attack was against the then Latho Manik Sim.
Anyway, the ground that has been taken that he has not been joined as a party.
Who has taken the ground?
The district council as well as the
We
respondent
have
7.
taken, yeah, also taken.
But you are in the know.
No, we don't
As
know.
to this device.
This information is only today that we come to know. We are district council. We are not supposed to know who's.
They usually maintain a list of all former CMs and deputy CMs.
Who issues the sanat?
We issue sanad only to the same.
Only the same, not the deputy.
The deputy CM, after the election of a new CM, a new deputy CM has been elected.
So it's the CM who nominates the deputy
Yes,
CM.
yes.
Well, there's another issue. When the inquiry was ongoing, both the CM and the deputy CM were represented by the same council. That inquiry was closed only in 23. So the fact that he expired in December 22 was not brought to the notice of the inquiry officer as well.
And that's beside the point now.
Lordship.
See, that would be a redundant issue as far as
Well,
That
the
point,
role of the deputy CM is concerned.
the main issue
in any
here
case,
is something
now,
else.
That objection that has been raised with regard to the question of non-joinder of necessary parties, this falls.
Well, that will be redundant. Let us accept that.
You can argue this point at the time of
Yes, yes.
What I would suggest is, my lord, the matter can be posted for hearing.
Should we keep this on record or should
For
I?
record, my lord.
In the meantime, my lord, parties, if they desire, they can file their affidavit.
You can do that. You can do that.
ठीक है.
At the hearing, the learned counsel for the respective parties are in agreement that this matter may be taken up for hearing in its entirety, in as much as the merits of the case, including the issue of maintainability, to be taken up at the hearing. It is also pointed out that some of the respondents have filed their response or affidavit only with regard to the issue of maintainability. In view of the situation, it is now allowed, the parties are now allowed, the respondents are now allowed to file any additional affidavit to cover the merits of this case as well. Accordingly, this matter is now posted for. Should I post it for the affidavit or should I post it for hearing?
Perhaps for affidavit, if it goes in for hearing and if they keep taking time for affidavits.
So one week's time would be good enough.
1 week should be enough, my lord. Because our affidavits by and large cover most of the issues.
2 weeks, man. I've already filed.
Yes, you file your affidavit as on the issue
Yes, on
merits
merit, my lord.
and maintainability.
Lordship, I have a suggestion. Let the matter be posted for final hearing, and in the meantime, liberty is granted to respondent to file affidavit, if so advised.
Leave it to lordship.
It's the same thing.
Yes.
Next time you'll say we have not been able to file the counter, then it goes to the next date.
Lordship.
My copy.
Accordingly, the matter is now posted for hearing. And in the meantime, the said affidavit or counter affidavit is to be filed with advance copy to the petitioner, who would in turn file a rejoinder if so advised. We give an advance copy to him. He can file his rejoinder. List the matter to 3 weeks.
Much highly obliged.
Item number 2.
This would cover.
No, my lord. Somewhat similar issue, but this relates to the election.
Okay, what do we?
This again may come up after 3 weeks, my lord.
No. This is for filing of a counter.
No, my lord.
This is 7 as filed. You have only filed.
What is the state of this case?
Let it be for hearing
It
also.
has been posted for orders, which means
Same footing, Your Lordship. Same footing.
We have filed.
There, in the previous case, the challenge is to the dropping of the inquiry, and this is with regard to the election of respondent number 7, that is Aina Maniksyam. Because the office of Latho Maniksyam fell vacant after his resignation, they started the election process in 2023, and he stood elected. So that challenges the election process. That's all.
no. So here only the counter affidavit is to be filed.
We have filed.
No, same. Let it be posted for final hearing, Your Lordship. This one also. We also have filed whatever we.
You have filed,
Yes.
Mr.
We'll rely on whatever we
Yes,
have.
Mr. Namburi, you are in this case. Yes, Mr.
I don't think I'm required to file this matter.
You know what is?
This is a challenge to the election.
Yes.
We have only
No, respondent number 6 will not be, will have any locus to file any reply here. This is directed against a respondent number, against Aina Maniksyam.
Who's 7?
I'm sorry. I have already filed. District Council has filed. 7 has filed.
I've filed.
So pleadings completed.
Yes, yes.
So maybe tagged along with the previous case.
Legal counsel for the parties have submitted that the pleadings in this case is complete, and as such matter is now to be posted for hearing. Accordingly, matter to be heard on the next date fix. This is the same of the 3 weeks.
Highly obliged.
Item number 3.
No. No.
3, 4, 5 are connected matters. Those ROC matter.
Yes, Mr. Debra.
I have some more instruction. I need to have the instruction in this matter.
Why?
You see, already they've said that already given the compounding.
You have been called upon to seek instruction as to what is the status of the petition or the application before the ROC.
So instruction not yet.
Whether the offence has been compounded or not, whether final order has been passed or not. For that, why would it take you so long? In fact, by this time, you should have been able to inform the court that this is the proceedings before the ROC. This is the last order passed. Allowed, not allowed, adjourned, not adjourned.
It come after
See, that, you see, just saying, simply standing and saying I have not received instruction will not do. It's incumbent upon you to at least check. I don't know who has instructed you or whether you have seek proper instruction. What the court wants,
concerned person who
what
is
the court
dealing.
wants to know is what is the stage of the case before the ROC. Because if the matter is ended there, this whole
Because
petition
similar
becomes-
matters, other matter already disposed of.
that is a different thing. See, we are not talking about those other matters which have since been disposed of. We're talking about
3 number and remaining.
I think the process will take some time, Lordship.
yes, you would be also.
That is what
be in
I'm
the
been
know.
informed, Lordship, that the process will take some time.
What is the stage then?
We had preferred the application before them. And even those other matters also which has been disposed of, Lordship, that also some time were taken.
See, Mr. Nopior, you have filed an application for.
We had taken steps, Lordship.
You have filed.
Lordship, we had taken steps.
Taken steps in the sense, no sense.
In the sense that to approach them for compounding, Lordship.
Exactly. So we assume that your application are before the ROC.
Lordship. No, Lordship, what has happened in this case, it's not just this financial year that they're trying to compound. There are other 5 financial years also, Lordship. So they are taking, I think they are taking steps, Lordship.
Your Lordship,
Not just one financial year which is before your Lordship.
If kindly regarding these matters, Your Lordship, if this petitioner, when they apply for compounding, they file this application through this internet, GLN1. So if they give me this copy of it, then I can see the status about this. Others matters it will decide, but this regular court matters, I can take this. This is the matter to be disposed of, irrespective of this whether other matter is pending or not. So this much I can even advise also. Now I am saying to them, and that they are saying we are verifying in so many matters. Even some extent, some other cases.
You give him whatever necessary information is required.
Lordship is before them.
Only the application they have submitted generated the receipt through internet through them only. Who has filed this application? Other than the person, nobody can check. Even ROC also not can check this one. So if they give this one, if there any defect or anything, then I can point out that this is the application and this is the defect.
It should be on record, Lordship, as far as the ROC is concerned.
It will be difficult to because centrally generated, it is difficult to find out.
Maybe he's finding it difficult to to locate.
And by the name of the company is not possible.
If there are a number or maybe I don't know hundreds of applications maybe there, or
Lordship, I'll try to supply some information.
if you can, if he says so, give some indication, give whatever number that you have.
Lordship,
He can check it up and then confirm. But we cannot
because
go
my
on
instructions.
in this way. We cannot go on.
In this way, I can find out when
what happened is-
even within 1 or 2 days, I can
it's
confirm
hanging.
what's the matter there.
Lordship, instructions is that it's not just one financial year. These petitions concerns one financial year. So they are trying to compound all other years as well, Lordship.
You will see in such situation, my this submission will be here that irrespective of the other financial year, will not be taking any actions about it at the moment. Let it be, and then particular this court matters. After then, I will instruction to the ROC finish this one first, and other matters you go later on. At least court matter will be over. I can just suggest in this way.
I don't know how the mechanism works. That we don't know.
The Lordship, my just submission here. Suppose they have applying for 10 years to compound.
We
So
have
10 years it will be take time. Some companies even 15 years, government companies are there. So what's happened here, when we are in the litigation in 1 year, then I'll be advising to this ROC, let the matter to be first disposed of, because we are in the court. And other matters, when serially it is come up,
According to you, the ROC should take the matter, should take up the matter 1 year at a time.
ultimately they will be saying the 1 year. Even 10 years also they have taken, then separately it will be order passed. Separate order will be passed 10 years.
Yes.
So these matters when we are having, then this matter will go faster, as because it is everything is ready. Already we have filed these matters in the before this court, and this is a matter for financial some mistakes is there. So it will be quite different from the other maybe in other aspect. It may be for the it is for the purpose of the balance sheet in the year. Some mistakes was there, and others maybe they have reflected some amount, and it is different after inspection found. Another maybe this audit report was not correct, so not similar situated. So this is the different situation. So let it be covered. The ROC should not wait for other matters.
Whatever the case may be, you
I'll try to supply some
you
information
talk to discuss with Mr. Numpur, sort out whatever is the best possible way to to bring this matter to a close.
Lordship, we're trying our best also.
If I get the receipt, then I can 1 week there to listen in the matters.
Learned counsel for the parties have submitted at the bar that that according to the information received by them, it appears that the proceeding before the ROC, as far as consideration of the application or compounding of the offence involved, is yet to be disposed of. Mr. R. Devnath, CGC, has submitted that he may be allowed some time to seek specific instruction and to apprise this court of the decision by the ROC as far as these matters. On Mr. M.L. Dongpyo, learned counsel for the petitioner, has also submitted that the said application for compounding have not yet been disposed of till date, and no information has been received as to the stage. No information has been received as to the decision of the ROC in such matters. Accordingly, it is prayed that some time may be allowed for the parties to seek specific instruction and to apprise this court accordingly. On premium, the same is allowed. This is matter of the 3 weeks. 3 weeks.
Item number 6.
May I please, Your Lordship? Petitioner is not. So many times they have taken.
Just now they were here.
Yes, Your Lordship. And because of the petitioner is in overaged, that's why she was not regularized. Her initial, because petitioner, her initial appointment was under 3F, and that is temporary with an undertaking. She sought an undertaking. She has given an undertaking that whenever regular appointment will be made, she will be terminated. And not only that, when second advertisement was there in 2018, she filed an application for condemnation of her age. That also
My Lord, I have some difficulty today, my Lord, to take up this matter. In fact, my Lord, this matter was already heard, and regarding the age, my Lord, there was some confusion.
sir.
So I have already filed an affidavit also in that regard, bringing the birth certificate on
No, you
record.
see, even if you are disputing the age at this point of time,
My lord.
in this forum, that nothing can be done. If you are disputing the age as was stated by the by Miss Sarji,
My lord, in that
she was overage at the relevant point of time. Now you say that perhaps we don't know. There's some confusion as far as the age is concerned. So she would have been.
she was already in service, my lord. She was already in service on the basis of that same birth certificate also, my lord.
Okay.
She was already in service, and my lord, what has happened is I have challenged this this new advertisement, the recruitment process, my lord. It is not in terms of the advertisement also. My lord, I'll try to satisfy, my lord. Today, my lord, I am not in a position to take up the case, my lord. Any other date, my lord.
On premier by the petitioner, but is adjourned. Please stay after 2 weeks.
Obliged.
Manju.